This is the podcast of the Nova Center on Business, Human Rights and the Environment. Welcome.
Hello everyone, good afternoon. My name is Claire Bright. I am Assistant Professor at Nova School of Law and I'm also the Director of the Nova Center on Business, Human Rights and the Environment. It is my pleasure today to introduce our distinguished guests for our podcast. So we have with us today Kessedjian, who is Emeritus Professor at the University Panthéon-Assas Paris 2. She's also an arbitrator, a mediator, and an ICSID conciliator, and has started working on the field of business human rights and business human rights issues since the late 90s. It's also my great pleasure to introduce Filipa Cansado Carvalho, who is an independent practitioner here in Portugal with over 20 years of experience in international dispute resolution. Filipa and I will be conducting the asking the questions for the podcast. So let me perhaps start with a bit of a background. So Catherine, you have recently published an article in French in the Journal du Droit International, which looks at the Hague Rules on business and human rights arbitration. And this article is precisely what inspired this podcast. So perhaps I thought it would be helpful to start by setting the scene. You mentioned in particular in your article that access to justice is the weakest pillar of the UN guiding principles on business and human rights. And I wondered if you could elaborate a bit on this idea.
Well, thank you, Claire, and thank you, Filipa, for joining Claire on this afternoon. Between Lisbon and Paris, we'll imagine that we are on a bridge somewhere. The reason I say that the third pillar of the UN guiding principles is probably the weaker part of the principles is really because when you read the principles, you can see that the language that used by the third pillar is very broad language. However, when we need to think about dispute resolution, because the third pillar is about access to justice, this is a domain, this is an area of the law where you need to be concrete, you need to be precise, and you need probably to be more detailed than when you speak about due diligence or when you speak about general respect for human rights. I mean, access to justice is a very precise domain of the law. And therefore, I think the kind of broad language consensus-based that is the feature, the main feature of the UN guiding principles does not fit the needs of access to justice. And in fact, I'm going to say that when I started to work on this issue for the International Law Association, that was back in 2008. So of course, the guiding principles were in the works. They were not yet adopted. I wrote to John Ruggie. I wrote a message. And I told him what I was about to do for the International Law Association. And I told him that we were going to work on private international law issues, on jurisdiction and applicable law and enforcement of judgment. And he said, fine, this is good, because I was concerned that he would not find it useful. And he said, yes, absolutely. And evidently he had nobody on his team who were knowledgeable about these issues. And finally on this, I don't want to be too long on this introduction, but I think we need to remember that this is an issue which is a difficult one. And if you listen to the conversation that Heidi Hautala and John Ruggie just had, I was, let me say shocked that there was not a single word in the conversation about access to justice. And in fact, the only time when access to justice came up in the conversation was again when John Ruggie said he was not hopeful about the proposed binding legal instrument that is worked presently in the Human Rights Council. I mean, not that I am very fond of the draft text. I mean, you all know that I've been quite critical about the draft text, but that's the only hope we have right now to have something really serious about access to justice. So I was really sad when I listened to that conversation, and hopefully our conversation today may bring a little bit more to the general discussion on this topic.
Thank you, Catherine. And staying on this issue of access to justice, how do you see arbitration and perhaps even also mediation being an appropriate tool in the pursuit of better access to justice, especially when we take into consideration the fact that victims of corporate human rights violations are often considered as weak parties in this sort of disputes?
Yes, you are absolutely right. I'll start with your last comment. We are dealing with disputes between unequal parties. So there is an imbalance between corporations on one side and the plaintiffs who have suffered human rights violations on the other side. Now, it may be counterintuitive to propose arbitration and perhaps less mediation. I mean, I will not speak too much about mediation today because the Hague Rules are really about arbitration. But it is, I would agree with you that it may be counterintuitive to propose arbitration because arbitration, as we think of it, is really made for equal parties. It's mostly for contractual disputes, and it may not be the first type of dispute resolution mechanism that you think about when you think of disputes in human rights field. Now, what I would say about this is that, in fact, the beauty of arbitration is it is very flexible. So you can actually craft arbitral proceedings to the very needs of the kind of dispute that arbitral tribunals will hear. And so my knowledge of arbitration, my practice as an arbitrator has shown me over the years that arbitration can indeed be worked around to cater to this very imbalance between parties that you were mentioning in your question. So I think it is possible to find a good equilibrium between the different parties' interest. And also, we should remember that parties rarely come to those disputes alone. Usually they have an NGO with them, they have good lawyers who make it as their own business to do those sometimes pro bono cases. So I'm hopeful that we can find the right balance.
Thank you. And another concern that arises about arbitration is that it is a process based on the will of the parties. So how do you reconcile this fact with the fact that disputes between victims of human rights violations against corporations are tort cases?
Yes, again, I mean, you are putting your finger on one of the difficult issues. But again, as I just mentioned, adaptation, it is very clear that because we have no contract and therefore no previous relation between the corporation that is supposed to be the tortfeasor and the victims of its activities, that we cannot have a pre-activity exchange of will and exchange of agreement. So we have to work on a posteriori consent. And in fact, it is much better to work on ex post facto consent, because then the plaintiffs would know exactly what their rights are, what are the limits of their rights, and what are the full extent of their rights. And particularly, they can know, because they would have discussed that with their lawyers, they can know whether they would have a better chance before a national court and therefore not agree to go to arbitration. Really, what the Hague Rules are doing is adding one more possibility to the array of dispute resolution mechanisms at the disposal of plaintiffs. But I also have one more suggestions about consent. In fact, I could see, I don't think it happened already, but I could see that corporations could incorporate in their codes of conduct, in their CSR statements, in the way they are dealing with their due diligence, their reports, an offer to go to arbitration. We know that in the investment law regime, the states in their BITs are offering arbitration to corporations, to investors, and then the investor is the one who chooses when there is a problem with the host state. What I'm suggesting here is exactly the same kind of technique. Corporations would offer arbitration to the people with whom they will be interfering with their activities. And the plaintiffs, when the dispute arises, would have the choice to pick up on the offer or not, or deny the offer and go to court. So that's the kind of option that I think is good for the plaintiffs.
Thank you. And now let's turn more specifically to the Hague Rules on business and human rights arbitration. Could you perhaps tell us and tell the people that are listening to this podcast a bit more about the origin of the rules?
Well, thank you. I mean, the origins of the rules, as very often in international law or in life in general, I would say, trace it to the person, trace it to the person who had the idea. And we have to render to César what belongs to Claes Cronstedt. He is a Swedish lawyer, a very seasoned lawyer. He has had a lot of different experiences. And, to his tribute, he is the one who thought about arbitration as one possibility for plaintiffs who have suffered or who claim to have suffered human rights violations. So he was inspired also by Article 27 of the Ruggie Principles, which actually say that alternative dispute resolutions can be used. And he formed a small group of like-minded people who produced a paper that was widely circulated. And in 2017, he formed a drafting committee, and Professor Sima accepted to preside over the drafting committee. So that was the project, and the town of The Hague and the Dutch Ministry of Foreign Affairs accepted to fund the group. And in 2019, the Hague Rules were launched.
Thank you, Catherine. First of all, good afternoon, Catherine, Claire, and everyone listening. Continuing on the Hague Rules, your article alludes several times to the importance of transparency in business and human rights disputes specifically. And you comment that these proceedings are not just about remedy, but also about deterrence. Could you tell us how the Hague Rules deal with this issue?
Thank you, Filipa. Yes, I cannot reiterate more strongly than deterrence is actually one of the main goals, aside with compensation and reparation, of course. But deterrence is absolutely essential. And I think access to justice would miss its objectives if deterrence was not there. And therefore, we need transparency. We need that those disputes be made public, and we need that the awards being known, if not more, during the proceedings. And I will tell you a little bit about that. Now, the Hague Rules in the preamble say that we need, and I quote, a high degree of transparency. So that's already in the preamble of the rules. So I think the drafting committee was very clear that they agreed with this objective that I mentioned earlier. Now, having said that, of course, you can always do more. But what the Hague Rules do mainly is, one, they have chosen the PCA, the International Bureau of the PCA, which is the Permanent Court of Arbitration in The Hague. By the way, for the people who are students and who would listen to that podcast, I always remind them that the Peace Palace in The Hague was built for the PCA, not for the International Court of Justice. Very important, very impressive building. So the PCA was the very first creation of this movement of peace through international law that took place at the end of the 19th century. Anyway, parenthesis closed. The drafting committee chose the PCA as the administrator of the proceedings for the Hague Rules. And they knew by doing that the PCA has already had some experience in creating a transparent process, particularly with the Bangladesh Accord. So I think it is important to remember that the PCA has had that experience, and I think it was a good choice for the administration of the Hague Rules. Now, the second, I think the second aspect of the Hague Rules that is also very important is Article 28. Article 28 provides for third persons, entities or individuals to be able to participate in the proceedings, and they detail quite well the ways in which those third parties could participate in the proceedings. And they have been inspired by the Mauritius Convention, again, on investment disputes. So see, second time that I am referring to investment disputes as an inspiration for the Hague Rules. So again, I mean, we could have had a bit more on transparency, but at least those two steps show that the drafting committee was very, very serious about transparency.
Moving on to a different topic, you also emphasize the fact that a single individual cannot launch a dispute against a corporation, and that, more often than not, claimants act collectively. The reverse is also true, you say. Often claimants don't know exactly which company in the supply chain is at the origin of the tort. Could you explain us a little bit how the Hague Rules deal with these issues?
Well, thank you, Filipa. You are really getting to a very difficult point. The fact that you have a plurality of plaintiffs, I mean, most of the time, I mean, all the cases that we have seen coming, you know, I would say at least since the Rana Plaza, so since 2013, but there were cases before. We were less alert to those cases, but indeed there were cases before. So all of those cases are what I call complex disputes, very complex disputes. And so it is very important that any arbitration is crafted towards that complexity, to really cater for the complexity. I would say, and this is one of the few criticisms that I have for the Hague Rules, I think this is one of the weak points in the Hague Rules, unfortunately. Of course, as I said earlier, the Hague Rules could not go into many details about each proceedings, and it's good that they leave room for adaptation for each case on an ad hoc basis. However, they rely too much on the arbitral tribunal to do that without guidelines to the arbitral tribunal. So I think I would have liked to see, for example, more details on the notification, because when you have a group, what do you do? When you have a group of plaintiffs and a group of defendants, do you notify each one in the group? If there are thousands, do you do that by email? Is that possible, etc., etc.? I mean, all those details that may be very important for the very essence of the defense rights of the parties. Now, what about the hearings? You know, how the plaintiffs and how the defendants are going to act during the hearings. We cannot hear everybody. So will they have to elect representatives? How do you do that? The same is true for the allocation of compensation. You know, if there are thousands of people, how do you allocate the compensation that may be decided by the award? So I think these are very important points that perhaps we could have a protocol. We could have an additional protocol to the rules that would give a bit more guidelines to the arbitral tribunal. Turning to multiple defendants, I think one of the things that is really difficult, and that we come back to a question that Claire asked earlier, is that if we need more defendants than just the one that was identified at the beginning of the proceedings, are you going to be bogged down as a plaintiff because the new defendants will not consent? We should have invented a rule to say, a little bit like the French arbitration law does for a group of companies concept. I think we should have had a rule in the Hague Rules to cater to that very difficult issue, adding more defendants and not having necessarily their consent to come to arbitration. It's a tricky issue. I'm not saying it's an easy issue, but I think we should think about that because plaintiffs will need it.
Thank you, Catherine. Well, there's a lot of food for thought and discussion in what you just said. Moving on to a slightly different point once again, and brace yourself because this is a long question, but you criticize the fact that the Hague Rules do not require business and human rights knowledge from all of the arbitrators. While I understand your point, considering among other things, first, that BHR arbitration requires a myriad of other abilities from arbitrators, such as case management skills, you were just talking about this, and knowledge of arbitration. Secondly, that arbitration in general benefits from diverse tribunals. Thirdly, the prevailing understanding nowadays about arbitrators' conflicts of interest. And lastly, that parties frequently cherish the possibility of having a say as to the choice of at least one of the arbitrators. Might such a requirement not turn out to be counterproductive in the long run?
Well, I am not sure I understand the full reasoning that you just expressed, and particularly the last point in your question. I have a hard time seeing a backlash in the requirement of specific knowledge about business and human rights. You see, I am a bit torn between what seems to be your point of view, if I interpret your question correctly, and what I just answered, because it's true that in some instances, having no knowledge of the field may be an advantage. At least in mediation, that's what I would say, because sometimes you ask naive questions if you do not know the field. But I think in arbitration, because the arbitrator is rendering a decision that is binding and that the parties will have to implement, I do think specific knowledge of the field is better in arbitration. And the rules themselves in the preamble stress, and I quote, the importance of having arbitrators with expertise appropriate for such disputes. So the rules themselves, in my view, got it right on that point. And frankly, as much as I am working now in the field for probably 20 years, I can see that a number of my colleagues in the arbitration field have acquired some knowledge. So I think the pool of arbitrators is increasing every day, and particularly in the young generation. So it's very, very interesting to see that young lawyers become knowledgeable in business and human rights, and also have skills in arbitration. So I think it is really good about that. Now, I still see a small contradiction between the preamble that I just quoted of the Hague Rules and Article 11.1c, because in Article 11.1c of the rules, only the presiding arbitrator should have the knowledge. And there I disagree, because if you go all the way to form a tripartite arbitral tribunal, and that's where you're thinking in your question, and I would agree with you on that point. If you go all the way to appoint 3 arbitrators, you want a collegial decision. And if only the presiding arbitrator has the knowledge about the field, then he or she is going to take the decision mostly. And that is not good. So I find this a bit a contradiction between the preamble and that requirement. So on this point, we may be in disagreement, you and me, but it would be nice to have, the possibility to discuss further at any point in the future.
Undoubtedly, although I think that sometimes people think to be more in disagreement than they actually are. One of my concerns is the pool of arbitrators, and I take great comfort in your comment that people are interested in learning more about this very important topic. And we as arbitrators, as you know, we study the topics that we are not so familiar with, and a lawyer has to study throughout their lives. So I think that even when you have the obligation to study a topic, otherwise you cannot accept the appointment, I think. But also you can challenge, you are trained in legal reasoning, and you can discuss with a chairperson, because that's your obligation. It's not just to sit there and accept what the chairperson tells you. And so you can challenge the reasoning and help to reach a decision that is in accordance with the applicable rules. But I agree with you that I think we could discuss this in a podcast on its own, but we have still some questions, so perhaps that's an idea for a future podcast. You mentioned also the absence of appeal, and you say that this, which is, as you know, a typical characteristic of international arbitration, may be less acceptable in these types of disputes. So I think that you would favor a system with appeal, and if that is the case, would you favor an appeal to the judicial courts, or a system where appeal would be made to a second panel of arbitrators? And in terms of the substance, do you think a full appeal on the merits would be warranted, or that something akin to the English appeal on a point of law would be preferable?
Thank you again for another difficult and complex question. I would allow an appeal, definitely. I think these are cases where you have a lot of difficulties for plaintiffs to gather evidence. As I said, those are complex disputes, and therefore the chances the arbitral tribunal may not be fully aware of, how to go about deciding the cases may be one reason to allow an appeal. Another reason may be that, something has happened during the case, perhaps new evidence after the award has been rendered would come up that the plaintiffs could not gather before the award, etc., etc. So yes, I would definitely want to have appeals, whether to a new tribunal or to a court. I think I would be more inclined to go to courts. The reason will be mostly that we need to have a more harmonized field. We need to build case law. We need to build for the security, legal security, certainty of parties. We need more and more to build case law on these issues. And therefore, perhaps a court is better placed to do that, particularly on appeal. And I would open up everything. I would not leave it to, the classic recourse against arbitral awards. These are much too limited. I think I would really probably ask for full appeal on these issues. I'm hesitating. You can hear in my voice that I'm hesitating on those topics because, as I said, they are complex issues, and I am not sure I have completely thought through everything about that. So that's why I'm less affirmative than I would be otherwise.
I understand because I share your doubts. So, and it's difficult to talk about something that has not yet been seen operating in practice. I have a final question. I know you said that you were not going to talk a lot about mediation, but I think that all of us that believe in mediation need to speak more about mediation. So, and you end your article on a note of regret due to the fact that the rules did not go as far as they could have regarding mediation. So in your view, what is lacking? What rules should be added?
Well, thank you, Filipa. This is really close to my heart. And in fact, this mediation was the reason why I was invited to the launch of the rules in December 2019 in The Hague. I'm not sure the video is still available on the internet, but if it is available, you can listen to what I said there. Of course, the drafting committee didn't like very much what I was saying to them during the launch, but I am still convinced that they could have done at least one or two steps more in the rules. So, as you know as well as I do, we have come to a point in history where we speak about mixed mode of dispute resolution. We speak about, to take a big word, a holistic approach to dispute resolution. And therefore, a large group of arbitrators and mediators have gathered over the years to actually try to move things, not so much to med, arb, med, and so on, because you have to be very careful. There are lots of things that are said on that are not, in my view, perfectly well thought through, but at least to give more room to mediation while the arbitration proceedings are taking place. And of course, this has been encouraged by the Hague Rules, particularly in Article 1.6 of the Hague Rules. So it's there. I'm not saying they have missed the point. It's not. They have seen the issue. But in my view, they should have given more incentives to the arbitral tribunal to propose to the parties to go to mediation, to actually help the parties understanding their case much better so that they would know which issues could go to mediation, at least as suggested by the arbitral tribunal. They could have said that the arbitral tribunal could, suspend the proceedings while the mediation was going on. They could have helped the parties to find mediators, proper mediators, and so on and so forth. The timing of mediation is absolutely crucial. Doing mediation just before arbitration starts, this is the classic way. It goes nowhere, because before the arbitration has started, the parties don't really know the strengths of their arguments. But when you are in the middle of the arbitration or somewhere after the first briefs have been exchanged or the first rounds of evidence, then you know better where are your strengths and weaknesses. And then you are in a much better position to mediate and to try to find an agreement. So I think all those issues should have been, find room in the rules. Again, perhaps a protocol would be nice to add to the rules. And I find that Article 56 of the rules is a missed opportunity to have done all of that. I think it's good to give powers to the arbitral tribunal, but you should guide the arbitral tribunals. As much as we were discussing earlier the specific knowledge of business and human rights, I am actually quite surprised to see a lot of my colleagues on arbitral tribunals who know nothing about mediation. They have not been trained. They have not had any exposure to mediation. And they are not keen to actually abandon their arbitration powers to get the parties go to mediation. So I think there is a lot of education still to be made on those issues. So it's a pity. I think they should have done something a bit more. One good provision, though, in Article 56 is Article 56.2. where they say that a mediator cannot act as an arbitrator. And therefore, if you interpret the rules, vice versa. So if you are an arbitrator, you keep as an arbitrator. If you are a mediator, you keep as a mediator. And that's a good rule. So it's good that it is there, but they could have done a little bit more. So that's a regret. It's a minor regret, probably, because the rules overall are good. And again, I'm not saying that out of the blue, because I already said it publicly to the drafting committee. So they will not, if they listen to that podcast, they will not be surprised about what I say.
Thank you, Catherine. I agree with you generally about arbitrators in mediation and about the Hague Rules. But I think maybe it's just wishful thinking that things are slightly changing. You see, for example, that the ICC now in their new rules is pushing mediation onwards, and you see other signs, still discrete signs. And so hopefully in 5-10 years, the conversation will be very different. And also arbitrators under the Hague Rules will draw inspiration from new practices in international arbitration. Let's hope. Thank you very much.
That's
Claire.
a great conclusion. Thank you.
And on that note, let me thank you both again. Thank you, Catherine. Thank you, Filipa, for taking part in this very interesting conversation. Thank you for listening to our podcast, and stay tuned for our next episode.